In previous discussions, we made a distinction among unitary, confederal, and federal systems of government. We noted that the United States is a federal system, with a constitutional division of powers between a national government on the one hand and 50 regional or state governments on the other hand. When we examine the relationship between state and local governments in Texas, we find aspects of both federal and unitary arrangements. The division of governing authority between the state and home rule municipal or city governments has characteristics that are akin to federalism. Home rule cities have numerous areas of autonomous authority. General law cities are governed under the laws of the state. They have no autonomous decision-making authority. Thus, the relationship between the state and general law cities would be characterized as unitary. Texas counties, likewise, are also general law units of local government, and as such are limited to the structures and powers specifically granted by the state constitution and state law. Today, there are 254 counties in Texas. In the 19th century, counties were the most important units of local government in Texas. Texas counties trace their lineage from the Spanish word municipio, a word that does not translate directly to the English word municipality. During the Spanish colonial period, municipos were city-region jurisdictions comprising large geographic areas that encompassed one or more settlements and their surrounding rural territory. After Texas obtained independence from Mexico and the Republic of Texas was established in 1836, these municipos became counties, at which point their governmental structure changed to resemble the county organization in the southern states of the United States. Numerous new counties were created after Texas was annexed by the United States, but before the U.S. Civil War, and then again after Reconstruction and down to the turn of the 20th century. When the framers of the current Texas Constitution met in 1875, they quite logically spent considerable time and attention on issues related to counties, including creation of new counties, governmental organization, taxation and revenue, and other powers and restrictions. Nevertheless, the framers' attention was not very focused, resulting in haphazard coverage of these basic building blocks of government in the state. Article 9 specifically focused on the creation of new counties. After granting the legislature the power to create counties, quote, for the convenience of the people, unquote, this article lists a series of restrictions. New counties created outside the counties that already existed had to be no smaller than 900 square miles and, quote, shaped in a square form, unquote. The framers understood that this may not be possible in border areas and allowed that, in such cases, the area could be less. The framers also recognized that geographically large counties may seek to split into smaller counties. New counties created from existing counties could be no smaller than 700 square miles. However, they also must not be, quote, nearer than 12 miles of the county seat, unquote, of any county from which the new county's territory is taken. In the early part of the 20th century, several new counties were created in far west and south Texas, resulting in the current total of 254.